So I can see a few of you have read the examination of child pornography paper and reflected upon it. Remember that that particular assignment is due this coming Sunday. You should also be thinking about which federal law or law at the United States statute level you want to pursue for your project. And that said, we'll have a quick poll with which I'll launch, seeing if anybody has any questions about that project. So I will have a clue on whether any further discussion needs to take place. Looks like it doesn't so far. Give everyone a few seconds to participate. So I will, be happy to answer any question that you do have offline, since it's a minority that are searching for more clarity. So make sure that you reach out to me either through the chat box here, or you can shoot me an email at dmccusker470@alamantcc.edu, and we'll be able to move on from there. So again, I will just, for those who do not have my email address, which is in the syllabus, but I also put it in the chat. All right, to be sort of knowledgeable about the various laws and statutes that exist on the federal level, it will do us some good to see what a professional lawyer has to say on the subject. So we're going to take a few minutes here and consider what happens in a federal case.
I've been representing people in federal criminal cases for over 23 years now, and I've handled hundreds of cases in federal district courts across the country. Most of the clients that come to us really, they've never been through this process before. They've never had a federal criminal charge brought against them. So I thought it might be helpful just to walk through the steps of what happens in a federal criminal case. Now, the first step in any federal criminal case is going to be the investigation. And unlike a state case where a police officer may pull someone over on the highway and investigate, search the car, find some drugs or contraband and arrest them, in federal cases, these investigations usually take a lot of time. So you'll see more of a proactive approach by federal agents than you see in the state police law enforcement agencies who investigate state cases. The first step for a federal agent, once they've become aware of a potential crime, is they're going to gather evidence. And that can be as simple as a couple of agents going up to a witness's house, knocking on the door, and wanting to ask some questions. We call that a knock and talk, and we see that in almost every federal case. Sometimes they'll go talk to people who they think may be witnesses, and as they gather information, they may eventually come to the person who they think is a target or the potential defendant in the case and want to ask that person questions. We always tell our clients and their families to remember that if you get a knock on the door like that, you don't have to talk to the agents. You have a right to ask for your lawyer and to talk with your lawyer before you agree to an interview. Remember, these agents are trained and they're there to get information. So they have a way of trying to get you to talk even if you don't want to talk. But remember that you have rights and do not have to consent to an interview and do not have to consent to a search just because agents come to your door. You're not going to convince them to go away because you're such a persuasive person. Now, there's another way, of course, that agents gather information during an investigation, and that's getting search warrants. Perhaps they have information that there are drugs in a particular house, or a business has files that may show evidence of fraud. They can go to a prosecutor who will help them prepare an affidavit that they can then take to a federal judge. The judge will review that affidavit, and if there's probable cause that a crime has been committed or there's evidence of a crime, then the judge will allow them to execute a search warrant. And they'll execute that search warrant and try to gather as much evidence as possible. We see search warrants not just in searching businesses or homes, but we also, especially these days, see a lot of search warrants for digital evidence, for computer files, for social media, any type of evidence that a person may have that may be considered private. The government will often try to get access to that evidence through the use of a search warrant. But there are other ways to conduct an investigation and to get evidence, and that includes wiretaps and surveillance. We've seen many cases, not just in the drug area, but also in public corruption, bribery investigations, in undercover transactions involving securities fraud. We see the government engage in wiretaps. And a lot like a search warrant, for the government to get a wiretap, they have to prepare an affidavit, a very detailed affidavit, and go in front of a judge who gives them permission to do it. The rules are very specific about how they conduct these wiretaps and what they do with that information. So anytime one of those is used in a case, your lawyer is going to want to review it very carefully to see if there's a way to challenge it. And surveillance is also common in almost any federal case. Agents will set up and watch somebody. They'll watch a house. They'll watch a business. Sometimes they'll take video evidence. And that case, an investigation like that will mean that the case can drag on for a very long time while they're gathering evidence. We've seen investigations that involve wiretaps and surveillance last for many months or even a year or more. Now, of course, we also see federal agents involved in undercover operations, where an agent will act in an undercover capacity. They'll pretend to be somebody that they're not to try to convince someone or to allow someone to engage in criminal conduct so that they can record it and ultimately report it and prosecute the person. We, of course, see the government use informants, controlled informants, confidential informants. Sometimes people who are just trying to work off charges in their own case will agree to help the government in exchange for some sort of benefit, either financial, they'll get money for it, or they'll try to get a lower sentence. Now, those types of witnesses can sometimes jeopardize an investigation because they have their own agenda, but nonetheless, we see the federal government use them fairly often. Finally, there are grand jury subpoenas. It's very easy for a prosecutor to go to a grand jury and get a subpoena for documents or testimony that can then be presented to the grand jury when they're trying to decide if they're going to indict someone. Now, it's important to remember about a grand jury investigation that it's a one-sided affair. It's just the prosecutor's show. The defense lawyer does not get to question those witnesses, can't review the evidence, can't make any arguments to the grand jury. So when the prosecutor wants to do something with the grand jury, they're usually given pretty free rein. And if they want to indict someone, they're going to be able to get that indictment. If you receive a grand jury subpoena, you want to make sure that you're not a target of that investigation. If you are, then of course you have certain rights, and you're not going to want to show up in front of a grand jury and start answering questions about this investigation without having a lawyer involved and making sure that it's in your best interest. Now, once the investigation is complete, then the government has to decide if they're going to charge the person. And by making that decision, it can come through a grand jury indictment, or a prosecutor can make a decision very quickly and file a criminal complaint. But either way, the first step is usually somebody getting arrested. And that arrest usually will happen by federal agents, and the person will be taken to a federal judge. The first time the person appears in front of a federal judge, we call it the initial appearance. And basically all that's going to happen at that appearance is a magistrate judge will tell the person who's been arrested what they're charged with, what rights they have, and of course make sure that they have a lawyer. If the person does not have a lawyer at that initial appearance, and that happens many times because perhaps they weren't aware that they're going to be arrested, the court will appoint a lawyer just to handle that initial appearance and then allow the person to go out and retain their own lawyer before they come back to court. And in most federal cases, at this initial appearance, the person is going to be released on bond. The government will not object to a low bond, and in federal court, we usually see what we call signature bonds, where literally the person who's arrested just signs their name, promises to show up in court, and abide by certain conditions, and they're released that same day. But sometimes that's not the case. Sometimes the government will want to ask for a detention hearing. They will want the person to stay in custody without a bond until the case is over with. So if the government asks for a detention hearing, the magistrate judge will give both sides a few days to prepare and to come back and present witnesses or other evidence trying to show that from the government side the person's a danger to the community, is a risk of flight, we shouldn't let him out, and from the defense side that he has ties to the community, he's not a flight risk and not a danger to anyone if he's released. These detention hearings are incredibly important. So if the government's asking that somebody be detained without bond, the lawyer who's representing that person needs to make sure that they are very well prepared for that detention hearing to make sure the client can get out. Now, after the client is released, you're going to start preparing for trial. And that means you're going to go through the court process, you're going to be looking at the evidence, and you're going to be making decisions all along the way about how best to defend the person. The first step is reviewing the discovery material. Now, we call it discovery, and what it basically is information that the government has about the case that they give to us. There are specific rules in federal court about what they are supposed to provide. Good lawyers will ask the government for specific items of evidence, any statements that the defendant made, any evidence relating to benefits they've provided other witnesses, any searches they've conducted, all types of different evidence the government has to produce to the defendant early on in the case. But you can't stop there, because even though the government is required to present evidence that's not just favorable to their case, but favorable to the defendant's case, sometimes that doesn't happen. So we found that it's very important to conduct our own defense investigation of the charges. We need to talk to the witnesses. We need to review the evidence. We need to go out and inspect the scene. We have to do the same type of work that the government did way before this case was brought to court to make sure we know everything that they know and hopefully more about the case so that we can effectively represent our client. Now, our defense investigation is not just going to involve efforts that we take, but our investigators will be talking to witnesses. We will consider experts in an appropriate case. We will do everything we need to do to counter the government's evidence. Filing motions is a critically important part of a federal case. In every case, there's going to be some type of motion that you can file to push back against the government, to try to find out more about the case, to try to identify weaknesses in their case. And even if you don't win the motion, many times you'll get a hearing so that the lawyer can cross-examine the agent, ask them specific questions under oath that they can later use at trial. Some of the motions that we consider will be motions to dismiss, filed one last month that was successful. Motions to suppress evidence. We've had many of those that were successful and have led to dismissal of charges before trial. Many times before trial, we'll file what's called motions in limine to either get the judge to allow us to bring in certain evidence or to exclude certain evidence prior to trial. Motions are critically important, and they're limited only by the imagination and creativity of the lawyer who's handling the case. Ultimately, though, once you get through reviewing all the evidence, you know the case, you've had your motions hearings, you have to decide, are you going to enter a guilty plea or are you going to trial? Now, many lawyers will tell their clients, hey, it's a federal case, You're going to lose at trial. We need to work out a deal. And unfortunately, many of those lawyers will say that before they've even done their job, before they've done their homework and reviewed the evidence and filed the motions. In our experience, you don't want to ever enter a plea if you're not truly guilty of the offense. You can win a federal criminal trial. I've won many federal criminal trials. So don't be afraid to take a case to a jury if you have not done what the government said that you did. Because many times when they actually prepare that case in front of people and ask a jury to believe their version of the facts, doesn't always happen the way that they want it to. But there are cases where you're going to want to engage in a plea discussion with the government, ultimately end up with a plea agreement. Perhaps the government has a lot of evidence. You say, look, I did it. I just want to minimize the amount of time I'm going to spend in custody. And plea agreements are fine, but make sure you're getting something in return for pleading guilty. I've seen far too many people in federal cases agree to plea agreements that really doesn't give them any benefit at all. They had no need to enter the plea agreement. You can plead guilty without having an agreement with the government. But sometimes these agreements can be very beneficial. Let's say you're charged with an offense that carries a mandatory minimum. In a plea agreement, the government can agree to dismiss that mandatory minimum. The government can agree to make certain recommendations on how the federal sentencing guidelines apply to your case. The government can agree to specific sentencing recommendations. And in some cases, we've been able to get the government to agree to a binding plea. And you know exactly what sentence you're going to get when you go in front of the judge. And that's rare, but it does happen in some cases. But you don't have to enter a plea agreement. And if you're not getting anything in return for it, don't do it. Because many plea agreements, most plea agreements, also require the defendant to waive certain rights. No right to appeal, no right to make certain challenges to evidence, no right to ask for a lower sentence than the guideline. In many cases, it's better simply to not have that plea agreement and to go in there at sentencing and argue to the judge for a lower sentence. We've done that in many cases and gotten a much better result than the prosecutor wanted us to have. Going to trial can certainly be a very time-consuming, very anxious type of process. There are certainly risks to going to trial, especially if you're charged with a mandatory minimum. If you get convicted at trial and you have that mandatory minimum, there are only a few ways to get around it if the verdict is guilty. In many cases, you'll also lose some points under the sentencing guidelines if you go to trial versus entering a plea. But obviously, the benefit of going to trial is being found not guilty. And there's not anything, in my experience, that compares to the feeling when you can walk with your client out the front door of that federal courthouse after a jury has found your client not guilty of all charges. I've had it happen many times. And living with a criminal conviction in federal court is a very serious matter. So if the government doesn't have the evidence, you did not commit the offense, don't be afraid to go to trial. You just want to make sure that both you and your lawyer are very well prepared. So I hope this has been helpful to talk about the basic steps of a federal criminal case. Of course, if you have any other questions or if you or someone you know is going through this process, feel free to give us a call and we'll do our best to help.
Okay, so hopefully paying attention to that little discussion will help you maybe put some context around some of the cases that we have discussed thus far, specifically the James Bates case, and it's that's the one with the Alexa tie-in, the murder investigation, and Roger Lowry with the cash and the criminal conspiracy case there with the distribution of illicit material related to minors. So we know that in both of those cases, there was a discussion of gathering evidence, with the knock and talk being the first approach of the investigators. In both cases, search warrants were obtained. maybe not so much wiretaps, but indeed surveillance, observing the suspect in each case. We something to think about, maybe not in those two cases, but in other things that have been in the news of recent times regarding confidential informants, undercover investigators, is the possibility of coercion or baiting of the suspect, and the question of the legality of that kind of motive or operation. Once charges were filed and an arrest is made, each of the cases that we spoke about thus far would have had an initial appearance by the defendant. We know that in the Roger Lowry case that through most of the proceedings, he attempted to defend himself, which probably wasn't the wisest of ideas, but he did adamantly claim his innocence throughout his trial, and in fact throughout appeals. Later in the semester, we will walk through some of the run-up to trial, including discovery and the tie-in or relationship of expert witnesses at trials. So you can stay tuned for that. The mention of motions and the filing of motions should ring some familiarity to you, because in the James Bates case analysis, there was the nolle prosequi that was filed that basically says don't proceed. So the case was just suddenly dropped, ended, expunged. And in research of that case, we really, as private citizens, we don't have all the information that the judge or the jury would have, or the prosecutor or the defense attorneys. So we're not exactly clear on what smoking gun, so to speak, was brought forth that obfuscated the evidence and led to the conclusion that the multiple timelines could have played out, and that James Bates may not have been the perpetrator. Apparently, it was a strong enough storyline that the attorneys agreed to nolle prosequi. And we will take a look at yet another discussion that is pretty interesting overview of sexual assault investigations, and yes, many of the challenges that come into play when these types of investigations cause of a lot of the, like, the psychological harm.
It's more common than heart disease, the #1 killer of American women. It's more prevalent than diabetes, which affects 1 in 14 Americans. More women have experienced it than the 1 in 8 with breast cancer. The American Medical Society has called it the silent, violent epidemic. It is sexual assault, and 1 in 6 American women are victims. And for women in college, it's 1 in 4.
Statistically, rape and sexual assault is one of the most underreported crimes. The U.S. Department of Justice, in their most recent reports that I could find, which were 2007, in their estimation, only 26% of all rapes are reported. The FBI in their crime database say that 37% of all rapes are reported, so there's some difference. But basically, you're saying sexual assault is a very underreported crime. U.S. Department of Justice reports indicate that 70% of all rape and sexual assault victims know their assailants. A University Health Services study that was looking at sexual assault on college campuses, 1 out of 4 women had reported that they were sexually assaulted during while they were in college. 1 out of 8 women reported they had been raped while they were in college. And in that same report, 1 in 12 college males admitted to having committed acts that would meet the legal definition of rape. There is not a more personally violating crime than rape or sexual assault.
Dr. David Lesick conducted interviews with 1,882 male volunteers at the University of Massachusetts and Duke University over a 4-year period. He asked questions like, have you ever had sexual intercourse with an adult when they didn't want to because you used physical force, such as twisting their arm or holding them down if they didn't cooperate? Of the men interviewed, 120 admitted acts which met the legal definition for rape or attempted rape. Of those, 76 reported committing multiple rapes. The repeat rapists averaged almost 6 rapes each. The 76 serial rapists disclosed more than 1,000 offenses, including rapes of adults, sexual assaults, sexual and physical abuse of children, as well as acts of battery. These were disclosures not from men in prison, but from college students at prestigious universities.
Trauma is trauma, whether the tornado blew your house away or you were the victim of a violent crime, but certainly in the area of rape, you have been traumatized, and trauma has a certain impact on the human mind and the human heart and the human emotions, and you have to factor that in as you're interviewing a person, particularly in those early hours or days beyond the actual incident. There's a common phrase in crisis counseling that goes something like this, that's a normal reaction to an abnormal situation. There can be a sense of delayed memory or a sense of, they can be everything from hysterical to totally withdrawn. Emotions can be all over the map in terms of how they, what they're reacting to, and that can be interpreted often as resistance or as something less than cooperation. Unique challenges, and there are a couple that I want to point out. One is in the whole area of all crimes, sexual assault and rape, the lack of conclusive evidence is often a difficult task in terms of trying to build a case, trying to prove what in fact did happen, because as police officers, we're trying to collect evidence, and when evidence is lacking or evidence has been compromised, particularly in sexual assault, there is no penetration, there is no ejaculation, there is no physical evidence that you can point to that says we can do DNA tests, we can do, we can do samples that would lead us to a conclusive point, or a time frame has passed that that now makes that, even if there is a rape exam, then it's impossible to collect at that point, or the victim has cleaned themselves up, or they've done something that has tainted the ability to collect conclusive evidence. It often does come down in sexual assault and rape. Most victims know their assailants. It often does involve one person's word against someone else's.
Nobody likes to talk about sex in this country. It's kind of a taboo thing. We don't like to talk about our most recent sexual encounter, even if it was a good one. So why would we expect somebody to just say, hey, guess what happened to me?
The two chief reasons that sexual assault cases are so difficult to handle, frankly, from a defense perspective as well as a prosecutorial perspective, are number one, because of the nature of the offense itself. The inherent nature of a sexual assault case involves something very private, very personal, very intimate. And when that experience is twisted or perverted in some way and imposed upon an unwilling victim, it creates a natural level of discomfort, obviously for the victim, but also for all of those people who are brought into the picture by way of investigation, by way of justice. Investigators are uncomfortable uncovering and exposing those kinds of crimes. Obviously, victims are uncomfortable talking about their last sexual encounter in front of a room full of strangers. And frankly, jurors and judges are uncomfortable hearing it. Beyond that, sexual assault cases are difficult because oftentimes they are based on a lack of evidence. Again, by their very nature, there are few or no eyewitnesses to the crime except for the involved parties. And because of the nature of the crime, there's often a delay in reporting the crime. That delay often costs the prosecution. It costs the prosecution opportunities to gather DNA evidence. It costs the prosecution opportunity to uncover physical findings that corroborate the victim's statement. So it often is the case that sexual assault cases boil down to a he said, she said sort of situation.
Often there is a prejudice, there is a kind of a preconceived ideal, or we are kind of predisposed to an opinion. Particularly as a male investigator, you tend not to have confidence, or it's almost like the victim has to prove herself that this happened, and we go in with that attitude. And to me, that's a fatal flaw in investigative technique. I think another mistake or another difficulty that often occurs from an investigative standpoint is the issue of fear. It's a strong word, but I've talked to a number of police officers, police investigators, who really don't know what to do with a rape victim, so to speak. They're very uncomfortable. It's something that they don't know what to say. They don't quite know how to treat them. They don't know. It just makes them very, very uncomfortable, and so they tend to kind of stumble around, and some have even admitted it's fear, and they don't know what, they're out of their element. They don't know what to do, and so they make a lot of mistakes.
Sexual assault cases are particularly difficult to prosecute and, for that matter, investigate when the victim is related to the offender in some way. I think this is because of the dynamics at play, and investigators must be cognizant from the outset of those dynamics. It's imperative that investigators simply be aware of the mixed emotions, the confused dynamics that are at play, and the investigators have to recognize that there are some signals that will obviously conflict just simply because of the conflicting relationships. And investigators have to be on their guard so that they're not thrown either way, for that matter, because of those mixed signals. Beyond that, investigators need to be sure up front to establish an environment and an atmosphere that makes the victim unafraid and unashamed. It's often the case that when victims, in particular child victims, are abused or assaulted by those who are known to them, they are very afraid simply because something very personal has happened to them by someone whom they've trusted, someone whom they've probably perceived to be a caregiver or a protector. And that situation creates a great deal of fear for them. Victims also often feel for some reason that they're at fault, that they've provoked it or asked for it in some way, and so they feel a great deal of guilt and shame. And investigators need to be cognizant of that so that they can combat that sort of attitude and make the victims feel more comfortable in talking in an open manner.
I went with a friend of mine after work. She was actually supposed to take me home. Then she changed it and said that she wanted to change her clothes and she wanted me to go with her to her house. On the way to the house, she stopped at the liquor store. We did buy alcohol. I didn't plan on staying there very long. And we get there and her roommate was there. You know, it seemed safe at the time because we were sober or whatever, and I was only gonna have one drink, and then she said she'd take me home. I don't ever remember finishing the first drink until, and that's the last thing I remember of that night. And I woke up at 3 o'clock in the afternoon the next day. Beat up, didn't have my clothes, had blood all over Lisa's sweats. Had my hair pulled out, I had a gash in my skull, and I
Okay, you get the point. There's just a lot of trauma, lack of conclusive evidence, difficulty and discomfort in the following the timeline in this type of subject matter. And the important thing is there is indeed a lot of tie-in to those physical crime scenarios with technology crimes. In today's world, the amount of human trafficking, child predation, and other crimes of assault have just skyrocketed due to the ability to have networks that are obfuscated with VPN technology, with the dark web, and other mechanisms to hide identities, to be able to operate in at least perceived anonymity. And so we will, touch back over and over again to these predation crimes, and as they tie in to the digital arena. And you can watch the rest of that if you are so inclined. It is one of the links under, I think it's this one, sexual assault investigations. And we will conclude by taking a look at a short discussion on cyberbullying, since that is another big deal.
So the first question.
Whoops, I think we might have to do some things with audio.
Is what is cyber harassment and what is cyberbullying? Well, cyber harassment and cyberbullying occurs when somebody uses an electronic device or the internet to harass, intimidate, and humiliate you, or in our case, defame you online. Cyberbullying and cyber harassment is a growing epidemic. Almost 34% of kids in the United States of America have reported to have been harassed or intimidated or bullied online through social media. Most commonly, cyber harassment and cyber stalking occurs on social media. For example, more than half of all cyber harassment today occurs on Instagram, followed by a close second with Facebook and Snapchat. There are many problems with cyberbullying and harassment laws as they are enacted today. For example, although almost 50 states, all 50 states have enacted some sort of bullying law, very few have teeth. Very few of them define what cyberbullying means. Some of them don't even define what bullying means or harassment means. Adding to our frustration with cyberbullying laws is the fact that most states do not actually require schools to implement policies and discipline or training mechanisms for staff and teachers. Meaning once the cyberbullying happens, schools are free to do as they may choose. They may enact their own policies, but the law doesn't dictate what discipline needs to happen. As a further complication, bullying in school only applies in school or when you're on school property or at school-sanctioned events. It can also, of course, take place when you're using a school computer. But the problem is, what if the harassment or the cyberbullying is not happening at school? And most of our clients, that's the case. It's not happening at school. So the cyberbullying rules as they apply to schools aren't very useful to us. So what are the other options that you have? And what may be most obvious with the cyberbullying laws that are enacted in most states is they don't apply to adults. The Pew Research Center tells us that almost 3/4 of adults in the United States have witnessed cyberbullying and online harassment, and more than half have actually been harassed, defamed, or bullied online. So what do we do for adults in those situations? So the question is, what tools do you have as a parent or as a child if you are the victim of cyberbullying and online harassment? Well, thankfully we have defamation laws. Almost every state in the United States has laws that speaks to specifically defamation. What is defamation? It's the publication of a false statement about a plaintiff that is false, that is made with at least a degree of fault of negligence, and that causes harm. If we can meet those elements, we may have recourse for you in the event of cyber harassment or cyberbullying. With cyberbullying, the damages that we're looking for is really no different than a traditional defamation case. We're looking for evidence of humiliation, evidence of loss of standing, reputational harm, emotional distress, and of course, monetary loss. So as an adult, if you've suffered from monetary loss, let's say you've been defamed and bullied in the workplace and it's resulted in the termination of your employment or the loss of a client, you may have an excellent claim for defamation. Another very important topic in the online harassment and cyberbullying world is sextortion. What is sextortion? Well, today's day and age, it's very easy to take pictures of yourself or of others in a compromising position, right? We've all heard of teenagers getting a little bit too friendly with each other with their cell phones. So what happens when a teenager, or perhaps you as an adult, have sent a picture to someone who then tries to extort you? Well, what is extortion? Maybe they're asking for a favor of some sort. Maybe they're asking for money. Maybe it's some sort of blackmail that if you don't do X, I'm going to do Y. I'm going to expose you. I'm going to share this picture. So the question becomes, what do you do? So I want to talk just for a minute about who these bullies are. So oftentimes clients come to us with anonymous bullying, anonymous online defamation, anonymous harassment. What do? Well, sometimes we have to file a lawsuit and subpoena an internet service provider or an email provider or other third parties to discover the identity of who this poster is. And it's very difficult to oftentimes discover that it's sometimes a close friend, an ex-spouse, an ex-lover, a business partner, a competitor, somebody who's seeking the same job or gainful employment as you are. The list goes on. But the bottom line is it's important that you talk to counsel soon so that that evidence is preserved, and if we need to, we can timely file a lawsuit and obtain that evidence. In Arizona, the statute of limitations is 1 year from the date of publication. It's a very short time period to get our ducks in a row and file suit. So it's very important that you speak with knowledgeable and experienced counsel so that we can take the proper precautions and get you the recourse that you need. Let me cover some tips to cover sextortion, cyberbullying, and online defamation. The first thing to remember is don't blame yourself. This can happen to anyone. doesn't mean that you were necessarily reckless or are at fault. Second thing to do is immediately talk to a lawyer who is familiar with online harassment and online defamation. Oftentimes the issue can be put to rest with a simple demand without expensive litigation. Number 3, make sure to preserve all evidence. That includes the text messages themselves, the images, any sort of verbal communications if you have them recorded, any other written communications and documents that you may have. Save it and produce it to your counsel confidentially so that they can evaluate it and determine the next step. Number 4, make sure that you do not give in to any demands, whether that's through bullying or sextortion or any other type of demand that the person who is harassing you is making. Number 5, what should you say in response? You should simply tell the person to stop. And when you tell them to stop, you should preserve that evidence and send that to your counsel as well. Number 6, oftentimes it's advisable to change your email and the passwords to your social media. Remember, this could be happening on a common computer or device that somebody else may have access to, especially if this is at work. You shouldn't be doing personal things on work computers anyway, but in the event that this is happening at work, you want to make sure that you change your passwords and your logins to your personal social media, and you should advise your child to do the same if they're being cyberbullied. Number 7, after you speak with counsel, the next most important thing that you need to do is report it to the proper authorities. Who would that be? Well, in the context of school bullying and harassment and cyberbullying, you would report that at least to the principal, if not to senior staff who are trained. Oftentimes, you may fall on deaf ears, which is why it's important to then speak with your counsel of whether you should go to law enforcement if it's reached the level of a crime. If you've experienced cyberbullying, cyber harassment, or online defamation, give us a call at R.M. Warner Law. We've definitely seen a variety of different types.
All right, we don't need the commercial. So again, I want to remind you before the end of the class period that the assignment due at the end of the weekend is based on this PDF labeled 3.4 Examine of Child Pornography and the Modern Legal System. And some of the information that you gathered today through the videos will help give you additional context on that topic. And again, if you have a question, confusion, concern about the project on the federal computer crime law, reach out to me either by email, or you can use the chat here or in the next class period. So that's all for today, and we'll continue our discussions of various tie-ins to federal laws and then move into state statutes on next week.